Yeah, I will. I've heard a lot about provisions in arbitration agreements that, I mean, I can't dispute what people are saying they've seen, but I can say that I haven't been in the lines for, I don't know, a dozen years or so. I haven't seen agreements being enforced, at least against consumers, that require arbitration in some distant forum. Or require gross imbalances in fees, and I think the industry standard now is to pick up the fees, or maybe there are some that require a small payment. And one of the reasons for that is that the preemption jurisprudence of the Supreme Court has recognized that if you're effectively precluding access to the forum by whether it's fees or some other provision, that that is the kind of thing that a state can come in and say, you can't do it. Now, where the line is drawn is, of course, an open question. And I will confess that my background, my experience tends to be colored by the things that we have advised people to do, our clients to do over the years, and the clauses that we have litigated. But I certainly would not advise, not just because it was unfair, but because it was also just kind of futile to put in something that required a consumer to pay more than the claim is likely to be worth. And I think in most cases, at least if you have a class waiver as well, the consumer better not be paying much. The AAA may allow a certain level of fee in some cases, but that doesn't mean that a court might not find that you're effectively precluding access if you're asking someone to pay more to get in the door than it would take. Then they're likely to win if they succeed. But I do think the benefits for those who do get in the door, and especially those who get in the door and are subsidized, are substantial, both in speed, primarily in speed, and in the informality of the proceeding, which in many cases does not require attorneys, even for claims like Mr. Carlson's. I had a lot of, I don't get out as much as Mr. Kane. I've driven by a restaurant many times. I'll get in there at some point. But I had many discussions with people about the claims that were at issue there and why it would possibly cost $1 million if you're informally arbitrating a claim. So I'll get up there and do it, and maybe I have to hire an economist for a day and $5,000. But these are not. I mean, I'm setting aside the merits of the claims. It's pretty simple. There's a company with a lot of market power that is extorting fees, essentially exploiting fees and impairing competition, not permitting people like Mr. Carlson to use other credit facilities. I mean, this is not rocket science, and you may win, you may lose, but that's a risk that's evenly borne given the lack of an ability to appeal. Not to mention that often the first round is the only effective round before settlement, if you even get that far, in court. So I think that the informality, particularly of the smaller claims, but also for some of these that seem to be more complicated, shouldn't be underestimated. And in fact, the dissent in American Express and some of the argument, Justice Breyer, I thought I was hearing myself. He was doing all these hypotheticals and saying, well, you could go up there and you make a pretty good case in a pretty short time. There's a reference to that in the footnote of the dissent as well. So I don't think it's as absolute as sometimes the issues have been made out to be. I do think that those who don't have access to a subsidized arbitration proceeding often have nowhere to go. Most claims are individualized. Most claims are not the type that can get class action status or will attract a class action lawyer. And I think the benefits of class actions as well are greatly overstated. I mean, even the Consumer Financial Protection Bureau's study, with which I have many issues, and has been analyzed in various places, including the Chamber of Commerce's website, the Institute for Legal Reform. Even they find that 87% of those actions get nothing for anybody. And then of those that remain, you end up usually having a fairly small uptake. I think this is mainly the consumer side, looking at these numbers, and well under 10%, often under 1%. And indeed, one of the claims administrators in a case in Florida put in an affidavit saying that, well, for these claims, consumer claims, I assume, again, where notice is not by personal mail, uptake is a fraction fraction of 1%. And there are many of these circumstances where you see, and most of the money is going to the lawyers, both the plaintiff's lawyers and people like me, and not very much going to the people that are actually harmed or are claiming to be harmed. And I think you're going to get in individual arbitration, at least if it is fair and access is as clean as I believe it should be. And indeed, as we have advised our clients to make it for their consumers, that you are going to have improved access for the bulk of claims. And now that also, of course, raises the issue, which is a serious one, of so-called mandatory arbitration. And the issue there, I think there are two issues. There's a legal issue and there's a practical issue. I'll deal with the practical issue. If companies are not able to avoid the judicial process, there's no incentive to subsidize arbitration on this other side. It is not an easy thing to accomplish and to administer, and no one will do it. So you will leave one set of plaintiffs out for the benefit of another set of plaintiffs. Now, that's the legislature can do that, but you have to recognize that there is a downside as well as a perceived upside. And I would ask the committee to consider, whether the benefits are as overstated as the harms, I think, are overstated. Harms of arbitration are overstated as well. I don't want to take up too much time. Much of this has been covered by prior witnesses. I mean, one thing, however, is the notion that arbitration is worse than judicial resolution as far as results for consumers. And I think the limited there, and granted all the studies, everybody's from the CFPBs to the Mayor Brown study to all the other ones are limited in their data. But one by Professors DeHozo and Johns found that claims in the AAA, plaintiffs did a little bit better than in court, not much, but 53% as opposed to 50%. It's certainly not a biased forum. And another point that has been raised, or an inherently biased form, there are biased arbitrators. You have a whole panel talking about that. I think Mr. Kane explained the repeat player issue is probably overstated. I certainly understand that there are arbitrators, and I have had them involved in cases that I have tried, and with one wonderful exception, not succeeded in getting vacated, where the arbitrators seem to be from a different planet and not ignoring any known rules, whether it was a business or a consumer claim. But we've also heard the same many times, or heard the same from the people on the other side of the table many times, that judge is totally unfair. What was the jury thinking? What were they doing? So again, it's a comparative process. There are no absolutes here. We do, however, have some very, very strong rooted legal principles that I think preclude the court from treating arbitration. I'm sorry, so used to looking up at judges. Excuse me for that, but preclude the committee or the legislature from treating arbitration as a harm to be avoided and putting special requirements on how that part of a contract is negotiated and under what circumstances. There could be other, if you're going to change the rules for all contracts, that's very different. But I don't think you can do that. Even the Ninth Circuit has already addressed the notion that there's some kind of constitutional problem with arbitration. And the Ninth Circuit, no friend to arbitration, generally rejected it.
Thank you. Thank you very much. Just a quick question. Do you advise, as you mentioned you advise your clients, businesses, do you advise them to put in mandatory arbitration clauses in their contracts?
I have done that. I have told them the costs and the benefits, and some of them say, nothing doing. Because they say, or for this set of contracts and not for that set of contracts, not the ones that, some will say, this just doesn't seem right to us. It seems like the risks are too high. We want an appeal too. And obviously some of them, including AT&T Mobility, whom I represented and continue to represent, did put in an arbitration clause with. The current version includes some opt-out provisions. I don't think those are required. I'm not sure that a legislature has the power to require opt-outs. I do know that we have advised, and we are starting to see opt-outs in what I would consider the cutting-edge arbitration agreements, which I think, and they're intended to be more fair than the law absolutely requires. It's not clear that you can require it just because it's more fair, but certainly our view is the better practice is to err on the side of being more fair and providing the kind of access that benefits consumers and ultimately benefits the company because the consumers are happier.
Thank you. Questions from the members? Are there any questions? No. Okay. You're okay? All right. I just thank you all very much. I think to kind of summarize this, where we're at the moment, and then we have the arbitrator ethics issue coming up. From what I gathered, the point of view is that arbitrations have significant benefits because they are speedy and more informal, and the cost of the process is far less than going into a courtroom. Then the other question, the other side of that is, well, the unconscionability side, consent versus coercion as a mechanism, and I think that's where, at least for me, I just have some issues here, is if you mentioned that some of your clients decide, yes, we will put in a mandatory arbitration clause, but others think, no, they won't because it might be more fair. There is the opportunity for them to make that decision, and I think the concern from some of the witnesses, and I know in some of the articles that have raised this issue, is that deliberative kind of give and take doesn't exist so much anymore, and that seems to be, I think, part of the problem. I think is, maybe that's a unfair summary, but that's at least what I've gotten from this. And Mr. Plevsky, I'd like to give you a chance just to respond to that.
I want to go back to where you started so that we don't engage in somewhat of a charade here. Companies are not imposing mandatory arbitration and class prohibitions in order to create more access to justice or a quicker, easier way for consumers to sue their clients. This is about claim suppression. That's what the federal government found. The Consumer Financial Products Bureau found that it was intended to suppress claims. It had that effect. The notion that there's no statistics supporting the repeat player effect is simply not true. There have been any number of academic studies. Thank you very much for the posting requirements that this legislature passed. As a result, the academic studies have shown, at least 3 of them, statistically significant variances that repeat players win more often and they pay less when they lose. It has been documented. And in a hearing in the California Assembly, the former president of the National Academy of Arbitrators came and said that any arbitrator that tells you they're not concerned about the impact a large award would have on being selected again is lying. It's a reality, it's human nature, and we have to maintain reality if we're going to make good policy here.
Passion on both sides. This is almost fun. I really appreciate your testimony. I think we got a lot of good information. I have just one last question, and that is, how pervasive do you find the use of mandatory binding arbitration agreements in the state of California today? Are we seeing them in virtually all contracts, all consumer contracts, in virtually all employment contracts? Can anyone answer that?
Ever since the court allowed the prohibition of class actions, they have been promulgated everywhere you turn around. The class prohibition was an opportunity too good to pass up. In my employment practice, about 80% of my clients are coming in now with arbitration clauses because they don't want to be exposed to wage and hour litigation and equal pay litigation.
Would you say that, Mr. Kane, that's a fair statement from your clients?
I don't have any statistics.
Yeah.
I don't have any statistics, but my experience is similar to Mr. Falk's, that some clients say, yeah, I hear you, but no, we're not going to do that because the transaction costs of paying for arbitration are too high, or we're afraid that we will lose and we won't have an appeal right, and so we're just going to stay where we are. I don't have any statistics, but it's not, there's no monolithic answer.
Ms. Stebner?
Yeah, I earlier testified that in the nursing home, assisted living, but I also say in healthcare contracts with your physicians, with hospitals, those are in every single one of those as well. So anything in healthcare, anything in long-term care, anything as you age, you will see an arbitration contract in it.
Thank you all very, very much. Appreciate your testimony. We have one final group. It's on arbitration ethics. If we're going to have arbitration, if we're federally mandated, if it's the policy preference of the state of California, we have Jay Welsh. Ask Jay to come up. I know Jay has got to catch a flight. He is the Executive Vice President, General Counsel of JAMS. We have Mr. Palevsky, who is going to stay here and share some more thoughts with us, and Heather Anderson, the Supervising Attorney with the Judicial Council of California. We're going to give you each 15 minutes to share with us your thoughts, and Mr. Welsh, we'll start with you, because I know you have a challenge to catch a flight, I believe, and I want to thank you for coming in. Mr. Welsh is the General Counsel of JAMS, and we'll start with you, sir. Thank you for coming.
Thank you.